Welcome back to the channel. Today we're going to be doing Learning Unit 3, the story of law. So where law originated from, how it came to South Africa. This is honestly one of my least favorite units, but it is a very important unit. So we're going to go through it. Okay. So the learning outcomes for this unit is you need to be able to name and describe the 5 periods that played a role in the development, composition and content of South African law. Then you also need to explain the influence of these 5 periods on the development, composition and content of the South African law. The 5 periods in the history of our law: Roman law becomes Roman Dutch law, Roman Dutch law comes to the Cape, English law comes from Britain to the Cape, the recognition of African customary or indigenous law, and the establishment of a constitutional democracy in South Africa. So first we're going to look at the rise of the Roman Empire and the Roman law. Roman law was, as we know, it was a legal system. It was developed by the Romans, which was an ancient civilization. It was founded in Rome, 753 BC. Rome started as a small, primitive community with a primitive law, founding customs. Roman law had political periods and structures, a sophisticated culture and language, complex system of law, a legal science, basically. 27 BC, Rome became an empire governed by an emperor. During the first 2 centuries AD, Roman Empire with its culture and law reached its peak of development. The law applicable during this time was known as the classical Roman law. Roman law reached its peak because of its extensive juris writings, legislation promulgated by emperors, which is an imperial legislation, and one of the most important things the Roman Empire gave us, which lasted until today, was its legal system. Then we're going to look at the split of the Roman Empire and the decline of Roman law. So as we know, the Roman Empire split into 2 parts, Western and Eastern Roman Empire. The Western Roman Empire fell in AD 426. There were 2 reasons for its survival. Personality principle. Each person lived according to the rule of his or her own tribe, and Germanic rulers allowed their Roman subjects to continue applying Roman law. This law was not the pure classical Roman law of early Roman Empire, but the Roman law that was influenced by Germanic law. Roman Catholic Church, a powerful institution. Church law derived from the Roman Catholic Church that is known as canon law. Canon law had an important influence on modern law, a verbal contract. An example is, because of the canon law, a mere agreement between 2 people can be enforced by the law. The Eastern Roman Empire. So we have the Western and we have the Eastern. The Eastern Roman Empire, Justinian was the emperor of the Eastern Roman Empire from AD 527 to AD 565. He played a vital role in the survival of classical Roman law in the Eastern Roman Empire. Justinian's codification. Justinian codified the Eastern Roman law in an attempt to restore the Romanian Empire to its former glory. He codified, which means to write down, all the writings of the classical jurists and legislation by several Roman empires. This was called Corpus Juris Civilis. He failed in reuniting the 2 empires, but it did keep the Roman law alive in the Eastern Roman Empire. How Roman law became Roman Dutch law. The revival of Roman law in Europe. 12th century, renewed interest in Roman law. Medieval universities like the University of Bologna in Italy started studying Justinian's codifications. The reception of Roman law in Europe, 1500 to 1700, Roman law in Europe, the Netherlands. The current legal systems in Europe was unsystematic and scientific. Systems were fragmented, which means there were many kinds of systems. Roman Dutch law in Netherlands. Old authorities is still a reference in our courts, namely Hugo de Groot, Simon van Leuven, Johannes van der Linde, and Johannes Voet. Roman Dutch law comes to the Cape. Important place in South African history was the law of the province Holland. Netherlands experienced significant growth in the 17th century. Commercial trade started between the Netherlands and the East Cape via Cape of Good Hope. Dutch East India Company employed to control Dutch colonies. In 1653, Jan van Riebeeck came to the Cape to start refreshment station for ships. Roman Dutch law was applied in all Dutch East India colonies. Roman Dutch law became applicable in the Cape via custom. Cape was governed by the Dutch from 1652 to 1795, which is almost 150 years. The law was found in customs of old writers and court decisions. Roman Dutch law formed the basis of law in almost all countries, Western and Eastern Europe. English law comes to the Cape. British first occupied the Cape in 1975. In 1806, the Cape became a British colony. In 1828, formal law paved the way for reception of English law in existing Dutch legal administration. British authorities never abolished Roman Dutch legal system. However, the influence of English law increased in courts, legislation, and court decisions. Existing court structure in the Cape replaced with English court structure. English jury system was introduced and then discontinued in 1969. English criminal and civil procedure, as well as law of evidence, received through legislation. British statutes form part of Cape statutes. Judges and advocates received their training in England. Then we look at how South Africa becomes a union. In 1910, Cape, Natal, Transvaal, Orange, and Free State were unified. The Appellate Division of Supreme Court was established in 1910. This played an important role in combining of Roman Dutch law and English common law. Common law was the foundation of SA law until 1990. Then we look at custom or indigenous law. These laws were mainly unwritten. Indigenous laws lived in communities where writing was unknown. So obviously if the laws were unwritten, it had to be in a community where writing was unknown. Law consists of oral traditions or unwritten customs handed down from generation to generation. Laws known as African customary law. Dutch authorities did not interfere with customary law of the tribes. In the second half of the 19th century, the British colonial authorities started to recognize African customary law. Constitution of 1996 recognizes and develops customary law. Then we have our apartheid regime era, which was the race separation which started in 1905. I think we all know about apartheid. In 1948, the National Party won the election. This was the start of the apartheid regime. The laws of apartheid were statutes of parliament. During the apartheid regime, parliament was supreme. It did not matter that the laws were unjust, oppressive, or discriminatory. Any legislation could be passed. And then we had the first democratic constitution. In 1996, constitution was the first democratic constitution of South Africa. There were three constitutions before the 1996 constitution, namely 1910, the SA Union was formed, 1961, when SA became a republic, and 1983, when the constitution that established the tricameral parliament. The tricameral parliament was a parliament with three houses, one for each of the white, Indian, and colored population groups. These constitutions were not democratic. Only a small amount of South Africans had the right to vote. And then we look lastly at black resistance. There were riots against apartheid. Of course, there were riots against apartheid because apartheid was unfair and lots of people rioted against it. There was Sharpeville in 1960 and Soweto in 1976. The international community sanctioned SA, which is the ban of imports such as goods and weapons. When something gets sanctioned, it's basically almost a punishment so that the community can act right, and then the ban of imports such as goods and weapons can be taken away. So the international community sanctioned South Africa so that South Africa can act right. This pressure led to the release of Nelson Mandela and the unbanning of the Black Resistance Movement, the Pan-African Congress, and the African National Congress. The above-mentioned actions made it possible for negotiations to begin and establish a democracy. In 1993, an interim constitution and Bill of Rights were adopted. April 27, 1994, the first democratic election took place. The final constitution was written in a language that everyone could understand. It was written by the Constitutional Assembly, certified by the Constitutional Court on the 4th of December 1996, and the slogan for it is "Written by the people, for the people." Thank you so much for listening. I hope this slide really helps you, and good luck for everyone writing exams.